Ladies and gentlemen, we're going to get started. Welcome this morning to this session on the state duty to protect, challenges in implementation. Welcome to you all. Thanks for coming. My name is Mark Taylor. I'm a senior researcher at the FAFO Institute for Applied International Studies in Oslo, and I will be your facilitator for this session this morning. The guiding principles reaffirm the state duty to protect rights through policies, legislation, regulation, and adjudication. The guiding principles also, of course, define a business responsibility to respect human rights based on their impacts of businesses, activities, and relationships. And they identify the practice of due diligence as the method through which business entities can ensure their impacts do not infringe on the rights of others. In this session, we're going to focus on regulatory action and policy coherence, both in general, in how government regulatory action might ensure respect for human rights by business, and in particular how policy and law can create an enabling framework for respect, in particular with respect to due diligence practices by business. As we heard yesterday, and as we will hear today, governments are at varying levels and stages of implementation. But the message from yesterday, and I hope what we will hear this morning, is that there is progress in implementation and that there is a good basis on which to start implementation for those who are just beginning. So to lead us in this discussion, we're fortunate to have with us 5 excellent panelists who I'm going to introduce to you in a minute. But first, I have to remind you of some practical things that the Secretariat has urged me to make clear, and many of you, if you were here yesterday, will have heard this before. First of all, I'm to remind you that due to the large numbers of people who would like to speak, the Secretariat is keeping a speakers list that I'm bound to adhere to, and it's over there, you see, the person standing up there will receive your names and affiliations during the course of the presentations. Up until the end of the last presentation. So if you have a comment or question, please be sure to sign up before that point. So the Secretariat will endeavor to ensure that there's balance on the list, but if you feel your questions weren't answered or weren't heard, please feel free to buttonhole our panelists during the break. Those of you who do manage to get to the floor, I would urge you to keep your questions or comments brief. And I'll do my best to allow that you be heard within the time constraints that we have. Okay, so to lead us in this discussion, we're fortunate to have with us 5 excellent panelists. Dr. Anita Ramasastry, to my left, is the D. Wayne and Ann Gittinger Professor of Law at the University of Washington School of Law in Seattle in the United States. Mr. Liang Xiaohui is the chief researcher at the China National Textile and Apparel Council and a lecturer in business and human rights at Beijing University. Ms. Gretel Orake is the manager responsible for technical assessments in the Mineral Resource Authority of Papua New Guinea. And Mr. Gilbert Mandonoje, at the end to my right, is an expert member of the African Commission on Human Rights and People's Rights Working Group on Extractive Industries, Environment, and Human Rights Violations. And finally, but to begin our session, we're very pleased to have with us Mr. Richard Howitt, member of the European Parliament. Richard is well known to many of you, particularly those of you from Europe. From his job in the European Parliament, Richard has been a leading voice in the development of policy and law on business and human rights in Europe. He's held numerous positions, too numerous to enumerate here, around the issues of human rights and business and CSR, and we're very grateful he's made the time to be with us here today to kick off our session. Richard, the floor is yours.
Thank you very much, Mark. Good morning, everyone. I'm delighted to be with everyone on this distinguished panel, including a number of experts including yourself, that I am very happy to work with, but I'm also particularly happy to be here with the colleagues from Papua New Guinea, from China, and from the African Commission. Your participation is really essential to us moving forward, so I'm really pleased to be here jointly with you. And Mark, I think it's quite good at the start of this session to quote from Guiding Principle 1 under that heading, State Duty to Protect, the requirement for governments, and I quote, to take appropriate steps to prevent, investigate, punish and redress abuse through effective policies, legislation, regulations and adjudication. Now, I don't know how much additional investigation, or dare I say punishment, there's been, nor indeed new legislation or adjudication in the 18 months since the guiding principles were agreed. But I do think it is worth recalling this commitment made by every government in the Human Rights Council when we voted for the guiding principles. As a European Union, as you've already heard this week, we are instigating sectoral human rights guidance and national implementation plans on the guiding principles. I'm very proud that 19 of our 27 member states have already agreed or begun writing those national plans. I'm myself proposing that these plans be subject to a peer review mechanism, which of course is a well-known model to everyone here in Geneva. But being honest, and I had hoped that this forum would enable perhaps a more honest assessment of both progress and difficulties in implementation so far. Being honest, as a European Union, we are only just beginning to integrate the guiding principles into our external relations activities, and I would accept that we have so far failed the test John Ruggie once again repeated yesterday to act on the issue of extraterritorial jurisdiction. Now, in my presentation this morning, I want to concentrate on the real, honest challenges towards implementation of the state duty in relation to business and human rights and how these challenges can be overcome. And I want to suggest 4 in particular. The first is the obvious one, sitting here in Geneva, that there is always a possibility of a disjunction between policy specialists coming to detailed agreement within the UN, with the UN member states giving their unanimous assent, and having a real understanding and ownership of these agreements in national capitals to take forward what has been agreed here. It's why the EU has put such an onus on our national strategies, because if national public officials are involved in drawing them up, consulting on them, then they then have the ownership to take them forward and to implement them. The second challenge, and there's no point in hiding it, is the level of political controversy. We've moved a long way here in the UN, in the EU, and elsewhere in the world towards acceptance by business, as well as by others, of the principle of legislating in this area. But when I look at the European response to bring forward our own version of Dodd-Frank on company reporting on extractive industries, I won't hide the fact that in Brussels this has been very hard fought. But what's equally interesting to me, at least in the European Parliament, is that the draft agreement on the EU law we've been debating ultimately went further than that agreed by our US counterparts. We agreed to address project reporting, and we proposed to extend the scope of the sectors covered. What this example shows, I contend, to this session, is that legislation can be much more controversial before it's agreed and much more acceptable afterwards when everyone can see it working in practice. So there is an issue of political will. The third challenge I identify is the problem of compartmentalisation. We all know in this Human Rights Council that there are some countries where human rights violations are most prevalent, where there is a human rights infrastructure, but it exists to act as a shield to construct an appearance of respect for human rights, when in reality there is none. Even in the majority of our countries, where there is a commitment to respect human rights, the danger is that the knowledge of human rights specialists is not transferred to actual regulators, who then do not themselves have the real understanding of human rights, which is necessary if we are able to move forward. Our colleague Anita has written and spoken on that issue. So this week in Geneva, there's been a lot of talk about training, about developing tools, about building capacity. But if states are serious about state duty, we have to adopt all of this for our purchasers, our labour inspectors, our tax collectors, our trade advisors and our aid staff, our environmental health officers and everyone else who is at the regulatory interface between government and companies. And there is the issue of coordination too. In Europe, corporate responsibility policies are led by, in different countries, the business department, the environment department, the labour ministry. And you can see, depending on which is the lead ministry in that country, the different emphasis that results in the implementation of the policy. Now, there's no simple answer to this other than the obvious one about multidisciplinary and interagency working. But I do wonder whether the model increasingly being adopted since the update of the OECD guidelines on multinational enterprise for quasi-autonomous and multi-stakeholder national contact points attached to ministries, but not simply operating within them, might itself provide a helpful model. I wonder whether states might adopt focal points answering to different ministries and covering not just the OECD guidelines, but the UN guiding principles too, and other relevant international instruments. It could contribute to the objective of convergence, which we discussed in the earlier session about global governance. I pose it as an idea. And the last challenge I want to identify is how we turn state duty into states' duty. The imbalance of power that John Ruggie talked about yesterday isn't just between companies and populations. It's between companies and governments too. And in dealing with multinational companies, that increasingly means supranational government, which is why we in the European Union, the African Union, and other regional bodies in the world are very important stepping stones from the national to the global and provide a very interesting and relevant platform for action. But to some extent, the guiding principles are an example of a totally new form of governance, which we are creating to meet new challenges and which we are quite literally making up the rules as we go along. In the next years, that will, I hope, include too the setting of sustainable development goals for the world, the establishment of integrated reporting for companies as the global norm, as well as achieving agreement on binding carbon emission reductions. Each of these has potentially dramatic impacts on business, but each too will not be achieved without a substantive business contribution and substantive business support. And in calling on business to join us in governments in these joint endeavours, government has to be ready to undertake our own responsibility. Let me finish, Mark, by quoting, and some of you won't believe this, the Code of Hammurabi. It's the earliest example of law anywhere in the world known to historians and dates from the ancient Babylonian civilization. Let me quote, The first duty of government is to protect the powerless from the powerful. Here we are, nearly 4,000 years later, and we're discussing the very same point. And if we don't fulfil the state duty to protect, what we are doing, quite simply, is leaving people without protection. And that isn't just the first principle, it is our first duty. Thank you very much.
Thank you very much, Richard. Now I'm going to move on to Gretel Orake for the perspective from Papua New Guinea, and a very practical perspective. Yes, that one. Yeah.
Thank you, Mark. And thank you, everyone. I'm Gretel Orake. I am the manager responsible for technical assessments of any feasibility reports that mining companies submit to the government of Papua New Guinea, to especially the Mineral Resources Authority, which I work for. I will give you a little bit of background on Papua New Guinea and its mining sector, and talk about the Mineral Resources Authority and the human rights issues facing the mining industry in my country and the challenges we face. I will discuss them interrelated, and just basically to give you the situation in Papua New Guinea. Papua New Guinea is located about 5 degrees south of the equator and shares the borders with Australia to the north of Australia, and shares land mass of the New Guinea island with Indonesia. It has a land area of about 461,000 square kilometers, and it has a very varied geography and environment, from mountainous areas with forests to valleys and also islands. We gained political independence from Australia in 1975, and we have a Westminster government system. We're a democratic country. We have a constitution. We have a diverse culture. We have a population of about 6.5 to 7 million people, and we have about 800 different tribes, so different languages. We have abundant of natural resources, including fisheries, forestry, and the mineral resources. 85% of our population live in rural areas and depend very much on agriculture. However, for foreign exchange earnings, about 2/3 of that comes from mineral exports. So my job is really managing the mining companies that come in to the country, and so currently our GDP is influenced, like I said, mainly by the mining sector, but we also have a liquefied natural gas project coming up, and by 2020 we expect our economic growth to increase dramatically, and we're looking at about $24 billion by 2020 as our GDP. Based with this background, the mining sector in Papua New Guinea is not new. Early explorations date back to pre-World War I. In the 1960s, we had a copper boom, where you must have heard about the Bougainville copper on the island of Bougainville. And we also had octedi were discovered around in the 1960s. In the 1980s, we had gold boom. And then we had more mining projects established, including the Porgera and the Misima mines. Now, current operating mines, we have Lihir, Oktedi, Simberi, and Pogera gold mines. There's ongoing exploration throughout the country, and 90% of our country has at least mining tenements covered all over the country. So the whole country is under exploration, basically. There are future mines that we expect coming up, including Frida and Wafi. These are very big gold mines. The Mineral Resources Authority was formed in 2006 following an act of parliament that established this agency, the government agency. The UN Guiding Principles on Business and Human Rights was introduced to this authority only very recently in Port Moresby during a human rights forum organized by the UN office in Port Moresby in Papua New Guinea. So it is a new concept to me, and so that's the first challenge I face is understanding what is required of me by the guiding principles and what is required of the Mineral Resources Authority by the guiding principles. That's the first hurdle we must overcome. Now, with human rights issues in the mining in PNG, we have both direct and indirect human rights issues, and especially equal participation in projects. Our communities, they feel dissatisfied many times. This was showed in a civil war that broke out on Bougainville Island, which lasted from 1987 to 1997. Because the people were marginalized. They were not included in the decision-making of how the benefits should be shared. So this has changed. Because of this, the 1992 Mining Act was established to address participation by land owners or customary land owners, because about 80% of our land is owned by customary ownership, and only a very minute, not 80%, well, 80 to 90% is customary owned. The state does not own a lot of land, and where the mines are to be established, the land is usually taken from the land customary landholder and given via a mining lease to the mining company by the state in the national interest. So the local people, they feel marginalized in that decision making, and we try to manage that now with the Mining Act of 1992, where it has processes for consultation with the communities. Also, with land rights, the mineral deposits belong to the state, but the land and above the land, above where the mineral is deposited is, like I said before, mainly customary owned. And issues of relocation of landowners. If there is a mine that is to be established where an existing settlement is or village, people are often relocated, and when they are relocated, they are faced with the dilemma of, they might move from a land where they have tribal affiliation with, and now they have to move to another tribe's land, and this causes anxiety. So how do we manage this? This the state also has to do, but we usually do that with consultation exercises, which most times are not to the satisfactory of the landowners. And also with safe environment and climate change. Most of our big mines, like the Oktedi and Bougainville mine, they had discharged tailings straight into the river system that has destroyed the river systems. We are now faced with another challenge of managing the environmental degradation from deep sea tailings placement. So these are all the challenges we face in our mining industry. We also have deep sea mining with the Solwara 1 project is as the first one that we have permitted. Having said that, we now have an Environment Act that was passed in 2000, where it has adopted the environment impact assessment frameworks, where we consider both the environment and socio-economic impacts of any mining. So there is framework, there is legislation in place, and there is also space for improvement. And having this exposure to the guiding principles is an opportunity for us to improve. We lack the capacity, however, and we will need training on adopting the guiding principles. We will need expertise from the global community to assist us with regulating the mining industry in Papua New Guinea better. So, thank you.
Thank you. We'll now move to Gilbert Maundunoje for his presentation. Gilbert, the floor is yours.
Thank you, Mark, and thank you to UN Working Group by inviting me to be a part of this panel. I would like to address my presentation, unfortunately, in French. Merci.
Thank you very much. As I said, this will be coming to you in French, and I'll start looking at the African situation, learning the lessons from oil drilling in Chad and what the state and other stakeholders have been doing vis-à-vis their obligation to respect human rights in the extractive sector. Now, there will be 4 points to this presentation. First of all, I'll look at a number of facts which highlight the role of states as members of the African Union and states taken individually as they meet their obligations. Then I'll look at the particular example of Chad to highlight how role reversal takes place between the states and the other stakeholders in the protection of human rights in the extractive sector. And that will then take me on to some of the obstacles and challenges which African states face in the context of low levels of governance. And finally, I'll try to highlight a few lessons we can learn which will take us towards better human rights protection. First of all, to stress that the adoption of the reference framework, Protect, Respect and Remedy, which is the culmination of some fabulous work done by Professor Ruggie, all of this provides fresh opportunities for the global framework for human rights protection because it highlights the obligations which states undertake themselves when they ratify treaties and conventions, and then they extend those obligations to enterprise, which is a new important approach in Africa. Now, when you look at the framework of the United Nations, there is a twofold impact in Africa, for the continent and then for individual member states. In the African Union, some works and studies conducted by NGOs and other organizations have clearly highlighted the unconditional responsibility of states parties in preventing all forms of human rights and people's rights violations, including by non-state actors, enterprise in this case. And it also highlights the fact that concerns about human rights violations committed by non-state actors, particularly the extractive sectors, mining, oil and gas, that these are a real subject of concern. And these reports also highlight the fact that the exploitation of natural resources has a considerable negative effect on the environment, and it's important to protect that. Which then, all of it led the African Union, working through the African Commission on Human Rights and People's Rights, it set up a working group on extractive industries, the environment, and human rights violations. And I am a member of that. At the 46th, I've been elected to it in Banjul in 2009, even before the adoption of the UN framework. So all this goes to show that for the whole continent, for the African Union, there is an awareness of the need to protect human rights related to extractive industry. But that's not the case in individual states. And there are a few facts and situations which remind us that the duty of states to protect human rights in the extractive industries is far from being the case. You can take the case of the hanging of the human rights activist Ken Saro-Wiwa in November 95, the recent massacre of the miners in Marikana in South Africa, the current court case against Shell for pollution in Nigeria, court case in Hague, and the complaints lodged by populations in Chad, and I'll be addressing this particular case later on. They've addressed the compliance ombudsman in international companies to highlight a number of situations relating to the violation of their rights, and of course the fact that hardly any African states have ratified Convention 169 adopted in the ILO, or the only country in fact is Central African Republic, which ratified it 2 years ago. As Mr. Howitt stressed then, in individual states taken in isolation, there's no real will shown, at least in Africa, to protect human rights when major players such as the extractive industries bring their own interests to the fore, meaning that states, well, you could even say that they just abandon their duty to protect their own people. Now, when, as I said, you look at the low possibility of ensuring governance, states find it extremely difficult, and paradoxically, it's the international financial and banking institutions which start to play a role and help to protect human rights in the extractive sector. And that's a paradox. The example in Chad shows this quite clearly because, well, in fact, I'll take two projects. The Chad-Cameroon pipeline, where the World Bank has involvement, and thanks to the World Bank involvement, there's been much more done to ensure that a number of environmental and social standards are applied to protect human rights. And this was an important phase. And what happened was that it was realized that when the agreement between the state and the World Bank Group was broken off, all the mechanisms which had been set up didn't survive because the state itself hadn't committed to mobilizing resources and means to ensure the protection of human rights. The second example relates to the oil drilling project with a Chinese company involved, the CNPC. And we realize that if China Exim Bank hadn't become involved in the financing of the project, then the environmental impact studies and the environmental management plan just would not have been prepared and compiled. Because the state wanted the project implemented very quickly. They wanted to build a refinery and they wanted access to oil products. So, in both of the cases I've referred to, we found that the role of the international financing establishments was important, since it made a contribution to the protection of human rights for extractive industry operations. Now, since I only have a few minutes left, I'd just highlight a few obstacles. Yesterday, during the presentation from a number of European institution representatives, and the British and Norwegian governments made the point as well, they were referring to the need to compile national strategies to ensure that the guiding principles on human rights and enterprise could be implemented. And in African countries, this hasn't yet been done. Another element is the actual will, the desire of regimes to get their hands on oil and oil resources, meaning that they have a very short-term view of natural resource exploitation, whereas the mining sector has a cycle which lasts 15 to 20 years. So even if all of the conditions were met to establish protective legislation and safeguards, there wouldn't be a problem. But this hasn't really been factored in by states at all. There's also the fact that you have collusion, connivance, and a conflict of interest between officials and business interests, meaning that the human rights protection role is abandoned at the expense of access to resources. And you can also note the low amount of resources that states allocate to their supervisory and monitoring bodies. And we realized again that when the World Bank withdrew from the Chad project, the National Compliance, Environmental Compliance Committee, which was financed with IDA credit, just stopped operating because the World Bank withdrew. So there's no desire on the part of the state to use this instrument to protect the environment and human rights. So then, lessons. And I will conclude with the lessons on the implementation of this global framework for countries in Africa. First of all, the role of country of origin for transnationals is decisive when implementing the framework for protect, respect and remedy in host countries, particularly with low levels of governance. If companies from OECD countries operate in Africa, and in OECD countries they have very stringent rules to avoid double standards, that will help to implement the principles. And the second important element is that, contrary to what people might think, China is very concerned at the way its enterprises operate in Africa. In 2006, we saw the publication of a 9-point ethics charter which stresses the fact that Chinese companies operating in Africa must, or anywhere else, must respect local legislation, they must protect the environment and protect workers' rights. Now, the reality is that the weak capacity of states means that some Chinese countries do and some Chinese companies don't respect the legislation. But there's a comparative study which we carried out between my institution and a French university and the International Economy and Business University in Beijing. So it's a cross-cutting study which allowed us to draw a number of conclusions and to realize that in China itself, environmental regulations are very strict, and when inspections detect human rights violations by companies, they do impose sanctions and measures of deterrence. So African states mustn't be afraid of being able to apply rigorous legislation, getting states to protect the rights of their population. Thank you.
Thank you very much, Gilbert, and that's a perfect segue to our next presentation. Xiaohui, the floor is yours.
Thank you, Mark. And I will follow my African colleague on how these things are developing in China relating to human rights and business. And today I will focus on the human rights related due diligence in the Chinese business regulation system, especially the investment system. I'll present some recent development in the past several years, basically in the past 3 years on this issue, and they are all investment related. It's also important to notice that this process of development in human rights due diligence in China are actually going along with the development of guiding principles within the UN system. So first, about some background information. First, I would like to notice to highlight that in the Chinese official concept of the human rights is not about business and the individuals. It's about the public authority versus individuals or groups. So, which means in the public or Chinese official position, business cannot violate human rights in a legal perspective. But so that's why in the corporate responsibility to respect human rights is not embodied in any Chinese law or business regulation system. But if we look at the due diligence, I would say that for the past several decades, due diligence is largely left to business as a business decision. Although in 2005, when the company law was amended, there was a general mention of social responsibility in the new company law. But in the recent years, especially in the past 5 years, I noticed a trend, which is that the human related due diligence has become a regulation concern in many areas, especially for Chinese investment, both inside China and outside China. And I would like to present 3 cases or 3 examples in this regard. Please, next slide. Please, next slide. Yeah, that's it. Okay. One is about the safety of overseas Chinese investment enterprises and their employees and personnel. And the second one is it's about overseas investment by Chinese SOEs. And the last one is a very recent. It's about social stability risk of major investment projects. That's in China. As you can see, I categorize these 3 examples into 3 kinds, which are soft due diligence, moderate due diligence, and hard due diligence. You will find what these terms mean in a minute. First, about this first example, because in the past decade, the Chinese government is promoting the going out policy for Chinese businesses. So we see a very sharp increase of Chinese FDIs in many countries. So according to the MOFCON statistics, now there are over 18,000 Chinese enterprises investing in many countries with an overall asset more than $1.5 trillion. So with this booming investment around the globe, the management and safety of the Chinese enterprise and also their employees now has become a serious challenge for Chinese businesses. If you recall, many recent cases concerning hostages and assault and attacks on Chinese businesses. So that's why in the past 2 years we saw a serious regulations and guidance to to handle this issue, this challenge. I would highlight two regulations. One is the regulation on safety management of overseas Chinese invested enterprises, and then the other one is the regulation on the administration of foreign labor cooperation, because Chinese companies also dispatch beyond. Besides dispatch Chinese employees, they also recruit from local communities. So that's why the Chinese government are now trying to regulate the administration of foreign labor cooperation. Following these two regulations, there are two guidelines. I need to point out that regulations are actually legally binding for companies, but the guidelines is kind of recommendation and for them to implement the regulations. So if you look at this series of regulation and guidance, I would say that in this example, the due diligence is more about risk assessment. It's focusing on what you need to do after arrival, after your investment, rather than before departure. So, so in one of these guidelines, a very comprehensive due diligence investigation process is provided, with very explicit attention to investment environment. Yeah, but this requirement is not intended for the whole supply chain, and there is no actually monitoring process for how you implement this process, this due diligence. More importantly, there's no legal accountability or legal implications for these due diligence activities. So you can see this is quite a weak, these due diligence requirements. Next example 2, please. Next slide. Yeah. But when it comes to the investment by SOEs, by Chinese SOEs, I can say the Chinese government is getting harder on this respect, because SOEs are Chinese SOEs, especially this 117 central enterprises, they are backbones of Chinese overseas investment. So there is one ministry, which is the SASAC, State Asset Administration and Supervision Commission. They are trying very hard to regulate how these central enterprises, also SOEs, behave in many areas, including investment in other countries. So, following the opinions by the State Council in 2006, that's quite a general one. The SASAC released in 2011 and 2012 two sets of measures for how for state-owned companies to manage their overseas assets and also overseas investment projects. And within these two measures, there is a very explicit requirement on how you do due diligence. But I would say whether the due diligence include human rights issues is not very clear, because if you look at the module outline, it seems that the due diligence investigation and also environmental protection and labor rights assessment is separated. But if you look into the opinions and also the measures, there's a very clear requirement that the government, it seems that the government has the authority to do human rights due diligence for companies. Because according to the regulation, investment projects that may violate international treaties that Chinese government ratified will not be approved by the authority. And then the economic technical feasibility study is up to the enterprise itself, and the government will take care of the international treaties. I assume that this will include human rights treaties as well. So I would say such kind of due diligence is it's kind of a one-time business-focused exercise with a preset aim to obtain approval from the supervisory authority. So this means that you do need a standing system within the company to do due diligence from time to time. And also, these kind of requirements, yeah, I think this is a kind of improvement because these requirements, they apply to all SOE subsidiaries, also to their international subsidiaries. So I think this might be a trend of Chinese law going, extraterritorial. Yeah. In this case, there's a very strong liability clause for people in charge of the SOEs. If there is a serious flaw in risk prevention, there might be, there might be administrative and also penal sanctions for that person. So I think that with this liability in place, I assume most of the Chinese SOEs will take human rights into consideration when they conduct their due diligence for overseas projects. The last example is quite recent because this regulation just came out this September. It's about how you do due diligence within China, and it's human rights related. But the main purpose of this regulation, next slide please, is to, as I quote, is to promote scientific decision making and also democratic decision making, as well as decision making based on law, so as to prevent and mitigate social contradictions. So this actually applied to most of the major investment projects in China. This regulation is issued by the NDRC, National Development Reform Commission, in September 2012. When it's, as I mentioned, this regulation applies to fixed asset improvement that needs approval also or authorization from the NDRC or the state council, because if you want to do this kind of project, you need to submit application. Yeah, and in that application, you need to present that you have done due diligence. So there's a whole set of due diligence procedures, including how investigate and analyze the social risk, social risk, stability risks. So you need to be, you need to be careful between the difference between social stability risks and also social risks. And also the companies need to consult the people concerned or might be impacted by that project, and with the aim to identify risk points and how likely this will happen, and how big the impact would be. And then after this, they need to come up with prevention and mitigation plans. With all this in place, you need to identify the SSR degree to show how feasible this project would be. It's compulsory that this SSRS social stability risk analysis need to be included in project feasibility study and application for report, and it must be an independent chapter. And there are 3 degrees about this SSRS. One is it's high, medium, and low, based on 2 criteria. One is how large of the how many people will be, opposing to this project, and they have strong reactions to the project. And the second criteria is the possibility to trigger mass incidents or social instability. And you may have the then you may have you may ask how this will be assessed. There will be evaluation entities appointed by the local government. And then they will do a study and submit a report with conclusions on the degrees of the SSRS. The report will be a decision basis for NDRC and the State Council to approve the project or not. And then if the report states that this project will propose high and medium or high or medium SSRS, then this project will be approved, will not be approved. Low SSRS will be granted, but you need to take into some prevention mitigation measures in place. Yeah. So this is about the process, but they also give very strong accountability backup to this process. It's a twofold accountability system for NDRC and also for the evaluation entities. Yeah, that may trigger, administrative sanctions as well as penal sanctions. It's also important that to notice that NDRC asked their local chapters to establish similar processes according to this, or with reference to the regulation, so that the local authorities can also follow the same structure. I believe that this measure would be very necessary to lessen the infringement of many rights by big investment projects in China, because now it's really a big challenge for Chinese society. If this regulation is properly implemented, I think most of the Chinese business will be aware of this due diligence on social risks, on social problems at least. But if we examine this regulation from a legal point of view, you can see that the regulation is more about stability. It's not actually based on rights or human rights. So the only concern is social stability. So yesterday I really talked to some friend that don't be too excited about this regulation. It's not about social risk, it's about social stability risk. It's not a risk for people, it's a risk for the government. And then also the evaluation entities are appointed by local governments. It's not even by the central government. But for most of these big projects, they are actually backed up by local government. And people under possible impacts are only consulted, and they're not engaged, or they don't have any rights to participate in the whole process. Okay, thank you. Yeah.
Thank you. Excuse me. Thank you very much. Up next is Professor Ramsastri.
Thank you, Mark. And I'm pleased to round out this panel. I've learned a lot in just this morning. I wanted to also mention at the back of the room is a report on human rights due diligence and the role of states, which was co-authored by Mark Taylor, myself, and two other researchers, and Xiaowei was a contributor, and it describes some of the Chinese regulations and guidelines that were discussed today. So I commend that to you because it has a rich set of examples from around the globe of how states can regulate in the due diligence and human rights area. I'm going to just make a brief intervention, and we've gone from regional and country challenges and regulation to talk about sort of general issues and process. The first thing I'm going to talk about is the role of transparency and disclosure in the area of the state duty and how it relates to human rights due diligence and protection of human rights. The second thing I'm going to talk about is the role of multilateral institutions in actually setting up state-based due diligence frameworks and regulation. And the third piece, which is actually a little bit of a digression, but I think important from what we're talking about today, which is a large policy gap, which Professor Ruggie talked about in his keynote address, relating to this issue of gross human rights violations, some of which people would refer to as international crimes, and the area of the fact that there's a lack of clarity among nations and states as to business responsibility for those human rights violations when they're committed, especially extraterritorially. So to begin, transparency and due diligence, you've heard about it, I'm sure, in different panels and places during the forum over the past day. And I just wanted to mention that it's obviously a very important part of Pillar 1 in terms of human rights and due diligence. And I'm going to explain that with reference to two examples from the United States, which I think show you the ways in which states can use transparency and due diligence and disclosure regulation to actually create a due diligence requirement or at least due diligence incentive for companies. And there are two different ways in which that can happen. And given what we've heard about the challenge in host states of governance, right, the fact that you often want assistance from the investor originating states, transparency and disclosure may be very important. But it's important for all governments because if there is lack of resources and institutional capacity, transparency and disclosure is a requirement which places information in the public domain and then allows a lot of parties, governments, civil society, and the private sector to become part of that enforcement regime. So as states consider the burdens that they think may be present and the resource constraints they have, this is one area that may be fruitful for further exploration. In the United States, we've seen post the mandate in terms of regulation, two different ways in which transparency and disclosure has been used to try to change private behavior. The first is an example actually from the state, and by that I mean the state of California level, which is something which many of you already know perhaps, which is called the California Supply Chain Transparency Act. It's a regulation that applies to companies that are not only American, but companies that do more than $2 million worth of business in the state of California. California is a large economy, and so many companies which are actually from other countries are actually captured by this regulation. But what it requires is just a pure disclosure, a posting on a website of whether or not a company actually has, as part of its own internal compliance, undertaken certain steps to verify whether there is labor trafficking in their global supply chain. So this is a very minimal mandate because companies that are either not very global or companies that feel that there is no risk can simply post on their website, we do nothing. Okay? Now, the reason for this kind of a disclosure is that there's an underlying premise that other stakeholders, if they are concerned, will actually, once they find out that a company has no policy, will actually try to push the company through market forces to do something different. But it's a minimal regulation because it just says you just tell us what you do or you don't do. Right. Contrast that with you've heard again earlier about the Dodd-Frank federal regulation, which relates to conflict minerals. And Mark is more of an expert, so he can correct me if I misspeak. But the idea there is, again, it's a disclosure regulation. To the extent that certain kinds of conflict minerals are an essential component of types of electronics that are manufactured or sold, there is a reporting function which says you've got to identify whether the minerals that are used are either conflict-free or not conflict-free. Now, again, it's not saying that businesses must have conflict-free minerals in their supply chain. It's just saying, tell us which they are, free or not free. And in this, though, there's a heightened burden because you actually have to engage in due diligence to figure that out. So it's very different from the California example, which just says, tell us if you're doing anything. This is saying you have to do something because you have to be able to determine the origin of what's in your part. So there is a stronger due diligence compliance function in the regulation. But both are important, as you can see, because in either choice of regulation, governments are then asking companies to do something with respect to due diligence. Right? Why is this important? It's important, I think, for to identify and help overcome some of the challenges you've heard from our colleagues today. For example, within the African Union, which is that if another government has governance challenges, then there's an external force looking at and asking companies to account for their global activities. So transparency and disclosure can be helpful for home and host states alike. The other is, that for those of you who were here yesterday, though, is the one I really want to underscore, which is the relationship between Pillar 1 and Pillar 3. Okay? There is a great challenge with respect to access to remedy, okay? And to the extent that civil society organizations and affected communities and vulnerable populations need information to understand whether there even is a harm, and if there's a harm, how they can actually prove that harm, either in a court or before any kind of tribunal, is going to be very important that they have access to information. We keep hearing about new laws that require environmental impact assessments and other types of documents to perhaps be filed with a state regulatory body. What's important along with that is for states to consider to what extent that information must be transparent or disclosed or put into the public domain and accessible to stakeholders. And this is what's very important. And I want to underscore that that is very different from the general sort of right to know movement that we've seen. Right to know or freedom of information is about once a community knows that the government has information, they can go through a procedure which may involve actually having to go to court to seek that information through disclosure requests. Transparency and disclosure laws can avoid that process by saying initially the information is in the public domain. So right to know is an important part of this discussion, and so it is part of what states should consider. But transparency and disclosure from the start, I think, is an even more important part of providing stakeholders with information that is essential to their access to remedy. And so I really hope that we'll consider that. My second point is about due diligence as a process and the role of multilateral institutions. One area that I want to draw your attention to, which I think is very fruitful for understanding due diligence and this notion of connectivity, supply chains, and business relationships. And some of you may be expert in this, but this is the area of food safety. Food safety is analogous to sort of human rights concerns because at the end of the day, states are very concerned that the products that are consumed and used by their citizens are safe, right? Food safety is a global concern. As a result of this, you have at the international level, the WHO and the FAO having developed a due diligence standard, technical processes called the Codex Alimentaris, right? So that you have a multilateral body that has gotten together to help develop procedures and processes which are agreed to by a large body of nations. Right? And I think that's an important lesson for us as to how we can develop in the human rights space state-supported due diligence frameworks. You use the multilateral institution, and the Codex Alimentaris has then become embedded in the laws and regulations of many states in the world, right? Of different development status and different institutional capacity. You have a common standard, and that standard is then embedded in national law to create a state-supported due diligence mandate. I think that's important. And the analogy in the human rights context is to looking at, again, conflict minerals. You have the OECD developing through a multilateral, multi-stakeholder process, a due diligence process with respect to verification of conflict minerals in the supply chain. And as we've seen with the United States, that due diligence standard is then embedded in national law. So I think that looking to multilateral institutions for developing standards, which can then be taken back to states, is a way of creating policy coherence, which is what we're talking about today. And the third thing I just want to talk about is the policy gap that was identified yesterday during our opening forum with respect to gross human rights violations, and to step back and explain where that comes from. I think we're all concerned, but yet we haven't yet, even though the mandate discussed conflict situations, we still have a long way to go with respect to dealing with the issue of businesses that are from around the globe operating in conflict-affected areas. And what Professor Ruggie mentioned yesterday was the problem of to what extent businesses will be held to account for their complicity in gross human rights violations, and some people would identify those as being synonymous with international crimes, forced labor, crimes against humanity, plunder, pillage, piracy, etc. What is the confusion? The confusion arises from a major case before the United States Supreme Court, right? You've heard about it, Kiobel versus Royal Dutch Shell. And the confusion there was about the question of, are corporations, do they have duties under public international law for their aiding and abetting or their commission of international crimes? Well, where did this confusion arise? The confusion arose because the lawyers representing Royal Dutch Shell have made that argument before the United States Supreme Court, and you have some American judges or courts who've also questioned that issue. Well, what do we know about that question beyond what's happening in American courts as it's examined? The first thing we know is that corporations are not subject to the jurisdiction of the International Criminal Court. But Andrew Clapham and other scholars of international law have made the point many times over the past decade that the issue of the lack of the court's jurisdiction is not a question of whether the court has competence, but just one where nations couldn't agree on a standard for liability. And so they chose to exclude corporations. But it's not because they couldn't include them. Okay? That it's possible, it just has not occurred. Which leads me to the other point, which is what about states and national jurisdictions? And their prior research, some of which I've conducted, shows that countries that are parties to the International Criminal Court have existing laws on the books which hold both natural and legal persons subject to international criminal responsibility, meaning that companies from certain countries, a Canada, a France, a UK, if a company domiciled in that jurisdiction engages in serious human rights violations, theoretically they can be prosecuted in domestic courts under domestic laws that incorporate international crimes. It's a little complex, but the idea is there are examples of national laws that permit this to happen. So where's the confusion? The confusion comes from the fact that we don't have affirmative guidance from states actually acknowledging this. We've pointed to it. The laws on the books exist. They are there. We know that the International Criminal Court has chosen to exclude corporations, but they considered it. But what we need is for states to actually come forward and say, as a matter of ending impunity, this is a very important issue. So it's that affirmative steps of states doing that. And the only other confusion is about the fact that in some countries in the world, there isn't corporate criminal liability as a matter of law, in Argentina or Germany. But we've dealt with this in international treaties before. The United Nations Convention Against Corruption has already dealt with the fact that, yes, parties to that convention have to criminalize bribery, and that means creating sanctions for their corporations. Well, what that means for countries that don't recognize corporate criminal liability is that you just create administrative sanctions. But there's a way of dealing with this, and states have done it with respect to corporations in other contexts. So in terms of a policy gap, I think this is a serious one, but I think it's one where, again, states could move to just reaffirm, I think, what already exists and what has been demonstrated by many people, including Professor Ruggie. So I'll end there, and I'll just say with one last point, which is that Richard Howitt mentioned earlier that many bodies of, tax collectors, others, need to know about the guiding principles as they go about their work. We talk a lot about the need to build capacity and train on the guiding principles and human rights more generally. But for states, look to where you already have mandates that relate to human rights. And one example that's very popular now is human trafficking. A labor inspector may need to learn and identify when trafficking exists in a workplace. It's just about inserting and educating people who already have a human rights function, that they maybe don't call it that, about what the guiding principles are. So I think a shorter step is to just, wherever states see the opportunity, to insert the guiding principles as yet another part of the worldview of all of those different regulators. So thank you very much.
Thank you very much, Anita. The Secretariat has informed me that the questions list is now closed, so we're going to go to the floor for questions. We also are fortunate enough to have with us Michael Adu from the working group, who's been listening intently and is going to have time at the end to respond to what he's heard during the session, I hope. So to the floor for the first question from the government of Colombia, Ms. Adriana Hurtado. Please.
Thank you very much. First of all, I thank you for this opportunity to learn a lot more about how we as a Colombian state can initiate implementation of the UN guiding principles. I'll refer to a few first steps that we've taken. The first being the setting up of a working group, which is an interagency one comprising not just bodies responsible for human rights, but also those dealing with trade and industry issues and those responsible for monitoring the due functioning of the state. This working group will be responsible for formulating public policy in business and human rights in Colombia. And in the government, we've started a training process for the trade and business sector to achieve horizontal coherence, whereby the regulatory and operational trade and business sectors will deal jointly with human rights. As far as vertical coherence is concerned, we have taken the first steps through dialogue at the local level, not just with civil society organizations, but also with representatives of various ethnic peoples in Colombia, with local authorities and businesses operating in the regions, to try to work out in far more simple language what the guiding principles mean for day-to-day business operations. In addition, we seek to gain inputs from them to build up a public policy that covers discussions, international standards, while taking into account the particularities of each area of operation. Through these first steps, we've come up with a question for the panelists. What do you see as the most appropriate mechanism that this working group might have in Colombia to ensure systematic follow-up for operations that are respectful of human rights on the part of the business sector? Thank you.
Thank you very much. I'm going to take go through all the questions and then give the panelists a chance to respond. Next up on my list is, and forgive me if I destroy the pronunciation, Winand Kwadvlieg from BIAC.
Thank you, Chair. I would like to comment on what Richard Howard has said, that for the sake of convergence, it would be good if national contact points could cover not only the OECD guidelines, but also other instruments of international instruments of corporate social responsibility. The problem here is that although the subject matter of those instruments is very much linked, the nature of the instruments diverges a lot. And that is why it will be very difficult in practice to make the NCPs also deal formally with other instruments. On the other hand, the OECD guidelines are so broad that it will maybe not create much limitation if the NCPs limit themselves only to the guidelines. Thank you.
Thank you very much. The next speaker on the list is from the Indian movement, Tupaj Amaru. And I would remind all speakers to try and keep it short, just to a couple of minutes. Thank you.
Thank you, Mr. Chairman. I would simply like to explain and state that governments and states that have the duty to protect human rights and human dignity have failed. The United Nations, in its efforts to draw up a code of conduct, and that started in 64 and negotiations went on to 94, that failed because of the imposition, particularly by the United States and other Western countries, of their views, and that includes the European Union as well. And the attempt to draw up guidelines or principles that would serve as guiding principles in 2002, 2005, that too failed. So having said that, transnational corporations are infinitely powerful. They are super states compared to nation states. And there's no international instrument to regulate them. In the context of globalization, everything has become deregulated. What we need in today's world is a code of conduct. And this is an issue that was raised some 30 years ago. And I'll explain why we need such a code of conduct. When mankind, as is the case now, is succumbing to disorder and chaos in a world without law and moral ethics, we feel the lack of an international framework to regulate the activities of banks, financial institutions, transnational corporations even more keenly. The need for a binding code of conduct, one that is absolutely mandatory, is determined through various factors. In the new international economic order, there is no definition nor international criminal jurisdiction to try those responsible for international corporations, banks, or financial institutions accused of fraud, swindling, and illicit activities, interference in political life, corruption and bribery of political leaders, murders of trade unions, which are acts that are classified as serious crimes. Secondly, the invisible hands of powerful monopolies and holdings that are permanently looking for profits, earnings, value added, is something that instinctively operates on its own and is reluctant to accept jurisdiction of the receiving country. Human rights are of no interest to them. The countries of the North and the South have lost the capacity to regulate the transnational corporations and financial holding companies and that are established in their own territories, because frequently there's no reference to the terms of transnational ownership or the concept of corporate nationality, nor the legal studies dealing with this. Supranational financial and business entities are in fact neither national nor stateless, but they function vertically and subjugate and are subject to rather to the mother countries in the powerful Western countries. Thank you, Mr. Chairman, for allowing me to make the statement. Thank you.
Much. I'm going to interrupt there and let the panelists react to one or two brief points before we turn over to Michael Adu. Are there any reactions from any of the panelists? Richard, did you want to?
Firstly, to our Colombian friend, I know your country well, and I also wish your country's very emerging peace process well. Your country and your people deserve it. The problem, of course, as you know better than me, is that despite many sincere people in the human rights community in your country, in order for there to be genuine progress, there has to be a real feeling of security, peace, trust, in order for the human rights defenders to be able to properly participate in the initiatives that you're talking about. And of course, we know that many human rights defenders and of course people in the judicial system in your country who seek to investigate abuses are often themselves subject to death threats, murder, disappearance, or have to flee the country. And so what FIDH said yesterday in relation to repression against people who speak out against companies is obviously a huge challenge for your country, and it is very important that not just your country but all countries where those challenges exist acknowledge this first stepping stone, which is essential if we're to move forward. As far as our friend from BIAC is concerned, one is I'm grateful you spoke. There hasn't, in my view, been enough companies who've spoken in the interactive debate, so I'm really pleased that you spoke, and I hope other companies will do so. I'm slightly surprised that if someone was to say it's a bit too difficult, to unworkable, what I'm suggesting, I would expect that more to come from a government than business, because business that talks to me normally says they don't want lots of different regulatory bodies and functions and different demands. They want clearer, more streamlined, more concise communications from us in government. So I was slightly surprised from that point of view. But I'm not sure you're right, because Denmark is precisely doing this. And if they can do it, then I think that provides a very good example on that, as on some other things to the rest of us. So I only pose it as an example, but we need some fresh thinking. Let's not stick in these boxes. And it's the boxes that have harmed all of this. And so I ask for your support in relation to that. And finally, on the debate on the Code of Conduct, in a way, that's up to the UN member states. Under the Ruggie process, what John said was that he didn't want to spend so long talking about standard setting, which he said would take 20 years. He wanted to actually make faster progress on implementation. And to be honest, he persuaded me of that. It's not that there isn't a need for standard setting, but it has to be balanced against implementation. I'm sure Michael will comment on this, because I heard what he said yesterday in relation to the working group's role on that. But although I'm very sympathetic to the ultimate goal of getting a convention in the UN system, I think that's a perfectly proper goal for people to campaign for and to advocate for. You know, I think we should recognise from this debate that the UN Guiding Principles already, whilst not a convention, have some legal effect. And we should also recognise the multilateral processes that John called for yesterday from governments, that we've discussed in this panel, which are already going on to some extent and need to go on, that aren't starting afresh on this subject, but where we can integrate what we've learned and what we're committed to in relation to the guiding principles. And that may be, it's not what you want, I understand, this is a disappointing answer, I understand, but it may be that that is the best way that we can make real, concrete, genuine progress in this field.
Thank you, Richard. We're now at time, so I'm going to turn to Michael for some brief comments before we wrap up.
Microphone, please. Microphone.
Insightful contributions from the panel. We, as a working group, are immensely grateful and certainly giving us some serious food for thought. Now, talking about food for thought, a number of things have come up which I thought we really will have to revisit. We know for sure, and we insist as a working group, that the guiding principles are not a toolkit, and I think it's a phrase that John Ruggie uses very much. So we are pretty well aware that different institutions in different countries will have to go at different speeds. And yet, on this panel, we are asking for coherence, integration, convergence, consistency, and regulation. Now, this actually raises some very interesting issues of reconciliation. Now, for the working group, we will have to think very hard, long and hard, about how we reconcile these competing tensions. I was particularly struck by the different speeds at which different countries and different institutions are sort of moving with the guiding principles. Looking on the one hand at the speeds at which the European Union is moving, and the confession, if I may call it, that the guiding principles have only just been revealed in Papua New Guinea, which of course is a fact. And then we realize that the Chinese concept of human rights really doesn't quite recognize or doesn't quite take account of the private sphere. So we do have quite some difficult ways of convergence or integration or coherence at that level. But something that strikes me quite interesting is this concept of partnerships. Now, I often wonder whether some of these institutions could actually partner up, or these countries could partner up and begin to work together in some different ways. And the one thing that really strikes me is the African, Caribbean, and Pacific context of the European Union, and they have a framework already. And you would have thought that would be a good way to partner up. And I can think of other ways in which the partnership systems could also work. So the working group will probably consider that. The other issue, of course, is whether countries feel this is a bit of a burden. And Professor Ramasastry has actually convinced me, and I hope has convinced everybody, as probably not an extra burden. Taking account of existing institutional processes and readjusting them to take account of the guiding principles seems to me a very excellent way of carrying this forward. Now, I was quite tempted to spend a little bit of time to address one particular question, which is the question of whether we need a code of conduct. And Richard actually preempted it by sort of predicting what I probably want to say. First of all, no limits, there are no bars on the development of the guiding principles. But the point, of course, is that if we're going to go any further beyond what we've got, we really need to confirm that the present system does not work. As far as I know, the present system is working very comfortably and very smoothly perhaps not as fast as others will want it. And so I'll urge a little bit of caution to say, let us see a little bit further how far we can take the existing guiding principles before we begin to consider binding codes of conduct. On that basis, I have my instructions to wrap up, and I'd like to say thank you very much.
Thank you, Michael. First, as the chair, my apologies to those who were on the list who were not able to ask their questions or make their comments. Thanks to all for doing their best to keep to time, for a panel of interesting presentations. I think we should give them a round of applause.